it can scarcely be necessary to pursue such a question further. The want of jurisdiction in the court below may appear on the record without any plea in abatement. This is familiarly the case where a court or chancery has exercised jurisdiction in a case where the plaintiff had a plain and adequate remedy at law, and it so appears by the transcript when brought here by appeal. So also where it appears that a court of admiralty has exercised jurisdiction in a case belonging exclusively to a court of common law. In these cases there is no plea in abatement. And for the same reason, and upon the same principles, where the defect of jurisdiction is patent on the record, this court is bound to reverse the judgment, although the defendant has not pleaded in abatement to the jurisdiction of the inferior court. The cases of Jackson v. Sashton and of Capron v. Van Noorden, to which we have referred in a previous part of this opinion, are directly in point. In the last mentioned case, Capron brought an action against Van Noorden in a circuit court of the United States, without showing, by the usual averments of citizenship, that the court had jurisdiction. There was no plea in abatement put in, and the parties went to trial upon the merits. The court gave judgment in favor of the defendant with costs. The plaintiff thereupon brought his writ of error, and this court reversed the judgment given in favor of the defendant, and remanded the case with directions to dismiss it, because it did not appear by the transcript that the circuit court had jurisdiction. The case before us still more strongly imposes upon this court the duty of examining whether the court below has not committed an error in taking jurisdiction and giving a judgment for costs in favor of the defendant, for in Capron v. Van Noorden the judgment was reversed, because it did not appear that the parties were citizens of different states. They might or might not be, but in this case it does appear that the plaintiff was born a slave, and if the facts upon which he relies have not made him free, then it appears affirmatively on the record that he is not a citizen, and consequently his suit against Sandford was not a suit between citizens of different states, and the court had no authority to pass any judgment between the parties. The suit ought, in this view of it, to have been dismissed by the circuit court, and its judgment in favor of Sandford is erroneous, and must be reversed. It is true that the result either way, by dismissal or by a judgment for the defendant, makes very little, if any, difference in a pecuniary or personal point of view to either party. But the fact that the result would be very nearly the same to the parties in either form of judgment would not justify this court in sanctioning an error in the judgment which is patent on the record, and which if sanctioned might be drawn into precedent and lead to serious mischief and injustice in some future suit. We proceed, therefore, to inquire whether the facts relied on by the plaintiff entitled him to his freedom. The case, as he himself states it, on the record brought here by his writ of error, is this: the plaintiff was a Negro slave, belonging to Dr. Emerson, who was a surgeon in the Army of the United States. In the year 1834, he took the plaintiff from the state of Missouri to the military post at Rock Island, in the state of Illinois, and held him there as a slave until the month of April or May, 1836. At the time last mentioned, said Dr. Emerson removed the plaintiff from said military post at Rock Island to the military post at Fort Snelling, situate on the west bank of the Mississippi River, in the territory known as Upper Louisiana, acquired by the United States of France, and situate north of the latitude of 36 degrees 30 minutes north, and north of the state of Missouri. Said Dr. Emerson held the plaintiff in slavery at said Fort Snelling from said last mentioned date until the year 1838. In the year 1835, Harriet, who is named in the second count of the plaintiff's declaration, was the Negro slave of Major Taliaferro, who belonged to the Army of the United States. In that year, 1835, said Major Taliaferro took said Harriet to said Fort Snelling, a military post situated as hereinbefore stated, and kept her there as a slave until the year 1836, and then sold and delivered her as a slave at said Fort Snelling unto the said Dr. Emerson hereinbefore named. Said Dr. Emerson held said Harriet in slavery at said Fort Snelling until the year 1838. In the year 1836, the plaintiff and Harriet intermarried at Fort Snelling. With the consent of Dr. Emerson, who then claimed to be their master and owner. Eliza and Lizzie, named in the third comment of the plaintiff's declaration, are the fruit of that marriage. Eliza is about 14 years old and was born on board the steamboat Gypsy, north of the North Line of the state of Missouri and upon the river Mississippi. Lizzie is about 7 years old and was born in the state of Missouri at the military post called Jefferson Barracks. In the year 1838, said Dr. Emerson removed the plaintiff and said Harriet and their said daughter Eliza from said Fort Snelling to the state of Missouri, where they have ever since resided. Before the commencement of this suit, said Dr. Emerson sold and conveyed the plaintiff and Harriet, Eliza, and Lizzie to the defendant as slaves, and the defendant has ever since claimed to hold them, and each of them, as slaves. In considering this part of the controversy, two questions arise. 1. Was he, together with his family, free in Missouri by reason of the stay in the territory of the United States hereinbefore mentioned? And 2. If they were not, is Scott himself free by reason of his removal to Rock Island, in the state of Illinois, as stated in the above admissions? We proceed to examine the first question. The act of Congress, upon which the plaintiff relies, declares that slavery and involuntary servitude, except as a punishment for crime, shall be forever prohibited in all that part of the territory ceded by France, under the name of Louisiana, which lies north of 36 degrees 30 minutes north latitude, and not included within the limits of Missouri. And the difficulty which meets us at the threshold of this part of the inquiry is, whether Congress was authorized to pass this law under any of the powers granted to it by the Constitution, for if the authority is not given by that instrument, it is the duty of this court to declare it void and inoperative, and incapable of conferring freedom upon anyone who is held as a slave under the laws of any one of the states. The counsel for the plaintiff has laid much stress upon that article in the Constitution which confers on Congress the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. But, in the judgment of the court, that provision has no hearing on the present controversy, and the power there given, whatever it may be, is confined, and was intended to be confined, to the territory which at that time belonged to, or was claimed by, the United States, and was within their boundaries, as settled by the treaty with Great Britain, and can have no influence upon a territory afterwards acquired from a foreign government. It was a special provision for a known and particular territory, and to meet a present emergency, and nothing more. A brief summary of the history of the times, as well as the careful and measured terms in which the article is framed, will show the correctness of this proposition. It will be remembered that, from the commencement of the Revolutionary War, serious difficulties existed between the states in relation to the disposition of large and unsettled territories which were included in the chartered limits of some of the states. And some of the other states, and more especially Maryland, which had no unsettled lands, insisted that as the unoccupied lands, if wrested from Great Britain, would owe their preservation to the common purse, and the common sword, the money arising from them ought to be applied in just proportion among the several states, to pay the expenses of the war, and ought not to be appropriated to the use of the state, in whose chartered limits they might happen to lie, to the exclusion of the other state, by whose combined efforts and common expense the territory was defended and preserved against the claim of the British government. These difficulties caused much uneasiness during the war, while the issue was in some degree doubtful, and the future boundaries of the United States yet to be defined by treaty. If we achieved our independence, the majority of the Congress of the Confederation obviously concurred in opinion with the state of Maryland, and desired to obtain from the states which claimed it a cession of this territory, in order that Congress might raise money on this security to carry on the war. This appears by the resolution passed on the 6th of September, 1780, strongly urging the states to cede these lands to the United States, both for the sake of peace and union among themselves and to maintain the public credit. And this was followed by the resolution of October 10, 1780, by which Congress pledged itself that if the lands were ceded, as recommended by the resolution above mentioned, they should be disposed of for the common benefit of the United States. and be settled and formed into distinct republican states, which should become members of the federal union, and have the same rights of sovereignty, and freedom, and independence as other states.